Hey, good morning, everybody. I wanted to say welcome to our panelists and our participants. Thank you to the Our Children, Our Way Society for hosting this webinar. And just starting with introducing myself, my name is Sam Hull. I'm a member of the Frog Lake First Nation at Treaty 6 in Alberta. I'm the Child and Family Services Lead with the Confederacy of Treaty 6, and I am one of the supporting technicians for the National Children's Chiefs Commission supporting the Alberta region. I would like to start with turning to Judy Red Hummingbird to open the webinar in a good way.
Thank you, Sam. And thank you to everyone that's joined our circle this morning from across the country and from your respective territories and your home fires. Thank you for joining us this morning. I'll open up with a short prayer. Cooksham, Pelcook Creator, we thank you, Great Spirit, for today. We thank you that we're full of energy. Every cell in our body is energy. And we thank you for that, Creator, because we can stay grounded in a way when we do our prayers like this to invite that energy in from Mother Earth and the energy in from Father Sky, from Creator, from you, from the universe. And then we choose, we do not have to be scattered. We can call our energy in, Creator, and we walk with purpose and alignment, Creator. So we pray for that for today, and we look forward to walking in a good way, because we make today is what we make it, and we decide where we go next, and we choose how our energy is used today. So we pray for our energy to be used in a good way, and also to have health and wellness for our people, and also that we continue to walk our path in a good way, and also that we can look at how our light does not need the permission to shine. We each shine our own light, and also what we had learned through trauma, and we learned through lived experience. Our pathway is not a brick wall, it's a doorway, so we can open that in a good way. So whatever we came through, Creator, for our lived experience did not break us, it's building us. Just as our children are at the center, we're building that future with them. And we thank them so much to being in our center of our circle, and also that we can focus on the work we're doing with intentional mindsets, and also to nourish the future for our children. And please send blessings for our children and our families and our communities, all that we're thankful for, the Mother Earth, the water, and all of creation. And also that we can breathe at times, to be in that moment, the stillness, to reclaim that energy we need to continue the work. Sometimes it gets to be so much as what we're working on that it builds up, but we know we can stop, smudge ourselves, and become whole again, and then be able to do that work that's so important. We thank you for today again. We thank you for our ancestors. We thank you for our guardians and our helpers, the seen, unseen, and unheard. And also that we thank you for that purpose and that direction, and also that heart, soul, intentions that we have for our children, and the work that we have before us today with the loving justice plan, and with the work to end racism and discrimination against our children. So we thank you again, and we love you so much, Creator. We thank you for the ones that our loved ones that may have passed on. We pray for the ones that are sick and ill and infirmed. And we also pray that our children will be at our heart today, and in our thoughts, and all the decisions and work that we do moving forward with Loving Justice Plan. Cook's Jam, Cook's Jam, Cook's Jam, Cook's Jam. Thank you.
Hi, Judy. Thank you so much. Our panelists today are going to be Chief Pauline Frost, the chair of the National Children's Chiefs Commission, and Dr. Cindy Blackstock, the executive director of the First Nations Child and Family Caring Society. Chief Frost will first provide an update on the Commission's analysis of Canada's plan and their apparent strategy, and then Dr. Blackstock will share a comparative analysis of the Loving Justice Plan and Canada's plan, and provide some discussion on how these plans intersect with Jordan's Principle. Before I turn to our panelists, just a few housekeeping points. This session is being recorded and will be available on the Our Children Our Way website. We have French interpreters available on a separate channel for Francophone participants. We will save time at the end for questions, so please type your questions into the chat, and I will read them out for the panelists at the end. And finally, we'll be hosting at least 4 more webinars over the next few weeks to really dig into the details of the Loving Justice Plan and Canada's plan. We'll share the dates of those webinars as they become available, so please keep an eye out for that. I'll turn now to Chief Frost to introduce herself and share an update from the National Children's Chiefs Commission. Thank you, Chief.
Thank you. Thank you to our elder and knowledge keeper, Judy Red Hummingbird, for a beautiful opening this morning. I'll just start by giving you a little bit about myself. So I'm the chief of the Buntakwitchin First Nation here in Yukon. I am also the commissioner representing Yukon First Nations on the National Children's Chiefs Commission. In January of last year, I was appointed as the chair of the National Children's Chiefs Commission, and I'm just quite honored to have that role and also to bring some voice to the table with respect to our Indigenous representation across the country. I want to just start by giving you a bit of a perspective and a brief overview on 2 plans that were submitted to the Canadian Human Rights Tribunal on December 22nd. I'll just maybe start by saying before that we did provide through other webinars, and I'll just refer you to our website, lots of context around how this came to be and how we landed here with respect to CHRT 80 plans. So the Caring Society, Caring Society worked with the National Children's Chiefs Commission to create the Loving Justice Plan. Many of you contributed your wisdom, your experience, your lived experience. Of course, your regional engagement in the fall really reflected your perspectives, your plans as it relates to, the decades-long work that you've been doing with respect to Indigenous-led research and legal obligations, legal orders. The Loving Justice Plan is built around national minimum standards for ending Canada discrimination in First Nations and Indigenous children and family services, at the same time while creating space for regional variations to address distinct needs and circumstances. And that said, often there's questions around what does unique circumstance look like? What does a national plan look like? The National Family Children Services Plan was rejected for a reason. It spoke about children on reserve. It didn't speak about all children. It didn't fully address the barriers that were in place and in front of us with respect to program and service needs of our children. And so in the Yukon, the unique circumstances of each one of our region must be considered when looking at regional variations. In the Yukon, we have self-governing First Nations. 11 of us are self-governing, and you have 3 that are not self-governing. In that contemplation, we have to look at the Indian Act bans, and then we have to look at the self-governing nations in their context. The circumstances also, as it refers to agencies, for us, we have not devolved direct authority over and control over family children services. So that still rests with the Yukon government when it refers to agencies in the plan. And so that in itself is a barrier, right? You want to see opportunities for direct involvement with First Nations led governance and oversight. It has to reflect our research. It has to reflect our perspective when it comes to regional variations and unique circumstances. For us in the North, my community is isolated and remote, so often we think about remoteness factors, right? Price, population, remoteness, variances when it comes to unique circumstances. So a key feature of the Loving Justice Plan is ongoing governance and oversight by First Nations. So the plan puts First Nations in the driver's seat. We see this as the only way to fully and finally end Canada's discrimination, persistent discrimination. Canada in the driver's seat is not an option. It has to be led and guided by First Nations governments across the country. When it comes to funding, the Loving Justice Plan relies on evidence-based approach developed with some built-in flexibility. So some funding elements will remain as actual cost until a reliable baseline is established. So the actuals approach will remain available to address distinct needs. Capacity building is included to support nations and agencies that need additional supports. While on the other hand, Canada's plan includes a national framework based on a failed final agreement, the one we rejected more than a year ago. Canada has made regional agreements a center. Let me just start again. Canada's made regional agreements a centerpiece for their plan. The national framework leaves very little room to negotiate these regional agreements. And under the plan, Canada remains in full control of all decision-making and leaves First Nations as an advisory role. That doesn't work for us. If we want to end discrimination once and for all and move forward in a cohesive fashion, we have to have First Nations leading governance and oversight. We need First Nations directly involved in implementation, not sitting on the sidelines watching in and providing periodic advice. That's not acceptable for us. So we have to look at a direct involvement, and we know that Canada obviously doesn't accept our advice because we've made some, distinct recommendations with respect to how we can change the policy directives and eliminate racial discrimination once and for all. So we look on this next slide, we talked about Canada's tactics. So we looked very carefully at Canada's proposal to negotiate regional agreements. And in the context of Canada's refusal to negotiate at the national level, the emphasis on regional agreements looks a lot like an attempt to divide and conquer. Essentially, what that means is that you're going to work region by region by region, and the money that has been identified, well, we think about how that's going to be divided. What strategies do they have in place with respect to negotiating region by region? How is the money going to be divided, right? Is it dependent on price, population, remoteness, unique circumstances? We don't know the methodology or the formula. That hasn't really been revealed. So in their refusal to negotiate, the Assembly of First Nations and the National Children's Chiefs Commission has been calling on Canada for over a year to negotiate a national plan. The Canadian Human Rights Tribunal ordered Canada to produce a national plan, and Canada came back with what we can define as a plan for regional agreements based on what we've read. Canada suggested that it is First Nations that want these regional agreements, and they point to letters they received from First Nations asking about regional negotiations. But what we are hearing is that is really a misrepresentation that BC Assembly of First Nations, the Assembly of Manitoba Chiefs, the Mi'kmaq Nation of New Brunswick have clarified that they support the national plan, and these are nations that have been highlighted in Canada's submission. So why then is Canada pushing these regional agreements? In our view, this is, as I said, the divide and conquer tactic, right? We know we're stronger together, and Canada knows that. Like, we have to work together. It's not, you can't hold us in this dilemma. It's like Canada's version of a sort of a, I guess you could coin it as a prisoner's dilemma. We separate us, impose an agreement that works for Canada. It has to work for us. We see Canada's usual tactics at work here. They're offering to negotiate, but these are not real negotiations, right? We have a plan, we have a strategy, we have a team ready to move on negotiating with Canada on a plan that will work for all nations. So this is a take it or leave it, right, approach with Canada. Canada Plan makes it very clear that there's very little room for actual negotiations. They suggested that they will negotiate regional governance models, but this is not real governance, right? In my view, it takes Canada, it gives Canada full decision-making authority and control over First Nations. and it gives First Nations an advisory role. So the funding structure and the amount are not subject to negotiations. Canada will negotiate to determine who receives the funding. We see this as a strategy for pitting nations against its own agencies. In our case, it would be Yukon government and Yukon First Nations, and then self-governing nations, and that against the non-self-governing nations. That's not a very good strategy, if you ask me. We also see Canada weaponizing time. So you see the tight timelines they've imposed in their plan. They imposed the schedule for regional negotiations. For regions that do not reach an agreement within that time frame, the national framework kicks in, although in reality, the national framework will apply to all regions, whether there's an agreement or not. But Canada adds to the time pressure by putting funding for regional structures at risk. If you do not negotiate a regional agreement on Canada's terms, your region may not get a regional secretariat. We finally see clear evidence that Canada is trying to deflect responsibilities. So in our view, Canada's goal here is to avoid accountability for ending its discriminatory conduct. Now, we will have more to say about accountability and enforcement in future webinars, but briefly, Canada does not articulate any mechanism for holding Canada accountable. Instead, Canada's plan states that agency accountability is a central tenet of long-term reform. This is not to be overlooked. Canada has been discriminating against our children and families for decades. To that extent, they are now paying over $23 billion in compensation, and yet they hold our agencies accountable. So the risk for all, however, is that Canada's plan may set up the nations to fail. There's no runway, no support, and no dedicated funding for First Nations that have not yet built up capacity to deliver services, which essentially puts our children at risk even further. There's power in our collective voice. We are stronger together. We came together in Calgary. We rejected the original plan that was not good enough for our children. And we already are seeing a clear win from the collective decision. Canada's put forward $4.4 billion annually going forward with a no end date. We can debate whether that funding is enough or not. Is it properly structured? But at least Canada has given up on time-limited approach, and it is a critical step in the right direction. And I just want to acknowledge that with Canada, we are, they did make some commitments. They came forward with the resources. Perhaps this is an opportunity for them to come back to the table to say, hey, maybe this is isn't gonna work, right? Maybe we should work together and try to implement a collaborative approach. That's ideally what we'd like, but for now, this is what we're seeing with respect to the divide and conquer, take it or leave it negotiations, and the whole business around accountability. You cannot force First Nations communities across the country and regions to fail. You can't force them into the corner and then say, here's 6 months, respond. That's not acceptable. We need to have, they need to put together their regional variations that work for them, and it has to be designed by them, not imposed on them. So we need to move in the right direction is what I'm suggesting here. And I'll turn now to Dr. Cindy Blackstock for her analysis on how Loving Justice Plan will keep us moving forward in the right direction. And I thank you.
Thank you, Chief Frost, for that. Just a reminder for the attendees that we will have some time for questions in a few minutes, but first we'll hear from Dr. Blackstock. If you do have any questions for Chief Frost, please feel free to type them into the chat and we'll come back to them in a few minutes. Thank you, Cindy.
Well, I want to begin by just recognizing the territories that all of you are on. And I am Cindy Blackstock, the Executive Director of the Caring Society. And I'm joining you from Tk'emlúps-Secwépemc First Nation. And thank you, Judy, for the opening. We're going to begin by picking up on some of the themes that Chief Frost has so eloquently outlined in terms of what is actually in the First Nations-led Loving Justice Plan to end Canada's discrimination in child and family services. And then what is Canada's plan to end its own discrimination? And how do the two compare, particularly on this whole idea of regional negotiations? So we'll go to the next slide, please, Sam. So begin with disclosure that the Caring Society is a co-complainant along with the Assembly of First Nations in the human rights case. So we do take representations, we make submissions, we're an active participant in that case. I also just want to say that this presentation is a high-level summary only. We always encourage everyone to look at the source documents. Most of them are posted on fnwitness.ca or on the National Children's Chiefs Commission's website. Included in those is a French and an English version of Loving Justice. Canada's plan, to our knowledge, is only available in English at this moment. Next slide. So a reminder that this is a legal case. These plans are to remedy Canada's discrimination permanently in child and family services. Jordan's principle will be addressed by a separate process, but as I will speak to later in this presentation, there is some overlap. Next slide. So how did these plans come to be? Well, back in August, I remember that the merits decision was actually made, and just a recognition here, the merits decision was handed down on January 26, 2016. So we just had the 10th anniversary of that decision. And what a world of change it has made, you know, like for children on the ground, for the people who are out there caring for them. It's been really a big shift. But it hasn't yet achieved the goal of non-discrimination or prevent recurrence. And so the tribunal has said to everyone, here are the minimum standards that need to be achieved in a long-term remedy. And so you see them here. One of the most important is that it needs to safeguard multiple generations of children from Canada's discrimination, not just 5 years, 10 years. It has to be multiple generations. That the cease discrimination order against Canada is the same as is kind of akin to an injunction. And they have to be based on evidence. They have to improve on the tribunal's orders, respect the spirit of the orders, and incorporate First Nations perspectives and regional perspectives. And here's an important thing. Respect the human rights of the child as well as First Nations. In some representations, people are making arguments that those two things are in competition with one another. But as UNDRIP makes clear, the human rights of First Nations children and Indigenous children coexist with the right to self-determination. Those things operate together. You can't compromise one for the other. They have to be in harmony with one another, i.e. self-government upholds children's rights, and children's rights are in harmony with self-government. Next slide. So the tribunal, in addition to those minimum standards, ordered Canada to create this plan and file it by December 22nd. And in fact, it really encouraged Canada to work with the Caring Society, the AFN, and the National Children's Chiefs Commission to come up with one plan. But Canada refused to do that, and thus it filed its own plan. On the other side, the Caring Society and AFN, you'll see there's no orders directly against the National Children's Chiefs Commission. That's because the tribunal can't make an order about a party that's not a formal party of the agreement at this point, although the National Children's Chiefs Commission has applied for interested party status. So the orders are against the Caring Society and AFN, and we were ordered to engage nationally outside of Ontario with First Nations and their experts, including young people, to develop a plan to permanently end Canada's discrimination in alignment with the tribunal's orders. And we had to file that by the 22nd. I just want to really recognize the incredible collaboration with the National Children's Chiefs Commission in the whole engagement session, and as well as Loving Justice. Next slide. So how did Loving Justice come together? Well, first of all, you need to know there was no money for this national consultation. But people got together and did it anyway. So the National Children's Chiefs Commission and Caring Society, supported by AFN, created the engagement guides. We've had previous webinars on that. You can go back and check that. And those engagement themes were informed by leadership direction, the tribunal's orders, and of course, decades of evidence that is already on the books. Thanks to the heroic efforts of people, we've had over 100 submissions from First Nations and their experts, including youth, that inform the Loving Justice Plan. And the Loving Justice Plan itself was blessed at a solstice ceremony at the Kamloops-Kwikam at the joining of the two rivers by elders and knowledge keepers, and particular recognition here to Judy Wilson, who really guided that process along with other elders. And when you look at the plan, the words "we love you," the phrase "we love you" actually is on the front and back cover in a way that it wraps it with love to try and really honor that message of loving justice across multiple generations. And of course, the plan's available in French and English. Next slide. Canada's plan was created in a very different way. The minister has made public statements that she's been speaking to rights holders about Child and Family Services and Jordan's Principle. But there are very few details about who she's speaking to, what the contexts are of those meetings, etc. There's no national engagement that we know of with First Nations experts or youth and anything close to what we did in Loving Justice. It does cite some evidence, albeit not as extensively as the Loving Justice Plan. And it, along with Canada's plan, which is 22 pages, it filed affidavits, 5 of them, I think, all of which are affirmed by public servants. So there's no real First Nations weight behind the plan. Next slide. So here's a quick summary. We've talked about some of this before, that it's really the goal with Loving Justice is to create comprehensive reform within an enforceable minimum standards as a national base, and then to create on top of that regional variations that respond to the unique needs of people. Here are some of the key things that we look at when we talk about effective comprehensive reform. One is governance. Who is going to watch over this implementation and the actual terms of the plan to make sure it actually ends the discrimination? In Loving Justice, that is a group called the National Oversight Commission, pardon me. And you might be saying, well, why isn't the NCCC mentioned there? It's because we wanted to give deference to chiefs and assembly in determining whether they wanted the NCCC to continue. Certainly its great work suggests maybe that's a good decision. But we wanted to just respect that by putting something in there as a placeholder that holds the similar structure of regional oversight. It has durable funding. It's not time limited. And as Chief Frost pointed out, when the Canada presented its plan to the chiefs in assembly back in Calgary, it said there's no way that they will provide any ongoing funding beyond the 10 years in that agreement. Well, that has now changed thanks to the advocacy of First Nations. And Canada has said that beyond the term of its plan, it will provide $4.4 billion in ongoing funding. So we need to look at the fine details, but that is a win for First Nations chiefs, and it's also a win for First Nations children, and Canada should be recognized for its step forward as well. Loving Justice includes capacity building funds. In a lot of the other plans, the remedy for communities with lower capacity is you can build your capacity by taking funds away from children's service money, whereas your high capacity neighbors can dedicate all that funding, presumably, to children's services. Well, that just puts in place an inequality amongst the haves and has-nots that we don't want to perpetuate. So we have a dedicated capacity building fund for those communities who may wish to assume some child and family services but don't currently have the adequate capacity. In addition to receiving the dedicated capacity funds, they can name another service provider to provide those services to their children while they build capacity, so that all children are guaranteed a minimum standard of service delivery. There's multi-layered oversight and enforcement, including a litigation fund for First Nations to be able to enforce any kind of plan or order, as well as an independent child rights monitoring mechanism. So these are just some of the additional things on top of the National Oversight Council and regional governance that helps provide a lot of eyes on it to make sure that children are actually not being discriminated against. Next slide. So here's Canada's plan. Chief Frost has covered a lot of this. It provides an amount of 27 billion. It's not clear how they calculated that amount. That is, I think, something that we need to learn much more about. It includes 4.4 billion ongoing after 2034. That's important. And it requires, Canada is still trying to dig in and get this declaration that its plan satisfies, supersedes, that means has higher weight than the tribunal orders and indeed replaces the tribunal's orders. It was developed without consultation with First Nations, at least that we know of. There's no real kind of declared consultation process akin to what we did in Loving Justice. It consists of a national approach that's developed solely by ISK. And that is mandatory for everyone. It doesn't change. And it really sets the major parameters of the agreement. There are regional agreements, but the nature of those agreements are limited with ISK imposed limits and really amount to implementation of ISK's national plan. There's very weak enforcement and independent oversight, and there's no designated capacity fund. So under this proposal, First Nations would likely be in the situation where they'd have to tap into their children's service money in order to build capacity, again, creating the have and have not scenario. That is something that we don't support. Next slide. So here's a quick overview of along some of the key dimensions. Again, this is not all the dimensions, and people should be going through the plan to look at these kind of key areas, but the major number one thing is stopping the discrimination. Does either plan really stop the discrimination? And as you can see, the Loving Justice plan really provides much more certainty in that direction than Canada's plan. And this is one of the areas where there is probably the most stark difference is whenever it comes to being able to enforce remedies and have independent oversight. That's where Canada's plan becomes much less detailed, more vague, and less convincing. And of course, we took the measures of including the voices of young people. I just want to join with all of us on the call in recognizing the voices of youth that are threaded throughout the Loving Justice plan. Canada really approaches children's rights and youth rights as beneficiaries of their plan, not woven into the whole fabric of the plan. And we'll go into more details on regional variations in the next few slides. So what is really Canada talking about when they talk about these regional negotiations? Well, it's implementation of a national preset model that was developed without First Nations input. That's kind of the high-level summary. Canada will fund regions for this approach. In fact, there's an announcement in Canada's plan that funding is available to regions who wish to explore Canada's plan. The key thing that people need to know, though, is the big decisions have already been undertaken by Canada. Canada's core funding levels, structures, and rules are already set. The regional talks really are about the administration and implementation of these core funding structures and rules. And the model itself really doesn't change from region to region. It's just how it's implemented. So, and as Chief Frost noted, if you don't conclude and invest an agreement with Canada by September 30th, or perhaps it's hard to know, by March 31st of next year, then you just get their national approach wholesale. So it falls short of really respecting First Nations self-determination and respecting children's rights. So in short, it's really regional negotiation about how to deliver Canada's approach. Next slide. So here's the timeline that Chief Ross talked about and the details. So you can submit a funding proposal under Canada's plan. Apparently, you can start regional negotiations already in January. You're supposed to conclude all the agreements by September 30th. And then Canada was going to file all these agreements with the tribunal. And these agreements take effect. And those agreements that are incomplete or for nations who want a different approach, you're going to get Canada's national approach anyway as of April 1st. That's Canada's plan. Next slide. So what do we mean when we talk about, I say we, I mean the National Children's Chiefs Commission, the Caring Society, and AFN. What do we mean when we talk about loving justice in the regional approach? Well, it's reinforced by minimum human rights standards that children are already entitled to under the tribunal orders and these were affirmed by resolutions by chiefs and assembly. So there's a lot of consistency. This idea of protecting multiple generations, for example, echoes both in the tribunal rulings and in the direction from leadership. It also includes enforceable oversight mechanisms and enforcement mechanisms. And then regions can decide what further measures are needed to achieve justice given the realities in their regions. So national reforms are a floor, they're not a ceiling. And regions can strengthen funding services and governance. Cultural, legal, and service models are region defined. And if Canada fails to engage in good faith, then regions can do as we did with Loving Justice, bring your own plan to the tribunal so that Canada isn't holding the power to set the pace of change. So really regional negotiations under Loving Justice is making reforms strong enough to truly end the discrimination for children in your unique circumstances, celebrating and honoring your cultures and your languages. Next slide. So here's a summary of the negotiability chart, and you can see the big picture items when we say that there's really no room to negotiate some of the big core issues. For example, the overall funding envelope, that's not negotiated in these regional agreements. The implementation is not negotiated from what we can gather. Getting rid of the tribunal's orders is not negotiable. And there's limited negotiation in the other aspects. I want to underline that this, again, is our preliminary analysis. We continue to look at Canada's plan and are welcoming the opportunity to look at its further submissions, but this, at this point, summarizes our current thinking. Next slide. So what is the relationship between child and family and Jordan's principle? Keeping in mind that the tribunal found that Canada's obligation to Canada failed to implement Jordan's principle fully, that was discriminatory. And its conduct in child and family was also discriminatory in the same ruling. Well, one of the things you need to know is they basically, those findings are from a shared base of facts that set out Canada's systemic discrimination towards children. So Canada was doing this systemic discrimination, and from that, we get the ruling of Jordan's principle and child and family from basically the same factual matrix. So they're both subject to orders for Canada to permanently cease its discrimination. It's not like 2 months, 5 years, nothing like that. It has to permanently cease the discrimination for multiple generations. The other reality, and many of you know this, children without supports are more likely to go into care. And child and family service funding, in the way that it is developed, is not sufficient to eliminate access to Jordan's principle. There will always be necessary for families who are in the attention of child welfare to also be able to access Jordan's principle. That's not to duplicate funding. It's simply a recognition that there are boundaries around what child and family service funding itself can fund. Next slide. So here's a good example. This is a mom who is, and this is from 2024. This is a mom who has a disability caring for 3 special needs kids. And Canada was saying, we're not going to fund home modifications so that she could continue to safely care for her kids. And indeed, Canada even called out the Child and Family Services to intervene in this case. Thankfully, Child and Family Services did not intervene. They recognized that the source of the risk was not this loving mother. It was Canada's failure to properly implement Jordan's principle. But you can see here that there are all kinds of historical links in Jordan's principle and child and family. In fact, we find that in the nugget of Jordan's principle in the National Policy Review that was completed in 2000 on child and family. Jordan's principle first appears in the Wande reports on CFS in 2005. And then in 2007, Jordan's principle was included in the CHRT complaint. So there's this nesting and overreaching. So it would be a mistake to think of them as 2 separate things. So when you're thinking about approaches for child and family, you have to take safeguards to and create some links to Jordan's principle. Next slide. So what's next at the CHRT? Well, there is a case conference on January 21st, 2026. And Canada actually made representations there that they are not considering any revisions to its plans based on its review of loving justice. Certainly, we've been looking at Canada's plans to see what, if any, of their proposals deserve consideration, but it's disappointing to say the least that they are not undertaking a similar activity. The tribunal is looking at what happens next in the proceedings, and we expect a ruling on that within the next several weeks. In the meantime, we are still desperately trying to bring Canada into compliance on the current orders on Jordan's principle, including revoking that discriminatory bulletin that has been highly criticized by the federal court and federal court of appeal and by the many First Nations leadership, and needs to go because it's creating serious harms for kids. In addition to that, we need to contemplate another path to permanently end Canada's discrimination on Jordan's principle in the mechanism of long-term reform. So that is the next steps at the CHRT. Next slide. So what can you do to help? Well, call on the Minister of Indigenous Services to have her adopt the Loving Justice Plan. It really is focused much more on getting it right for kids. And it is really informed by First Nations. It's not like putting out a plan and then getting First Nations to react to it. First Nations were critical to developing this plan. A call on Canada to fully comply with all the current tribunal orders. This should be a no-brainer, particularly in the worldwide context where we're seeing the dangers of states act with impunity and think that they are just rise above any accountability for human rights around the world. We in Canada need to stand as an exception to that pattern by really upholding human rights, particularly when they're legal orders and they involve children. And conduct your own analysis of Loving Justice in Canada plan and let us know your questions and observations. We entered this space with humility when we filed it. We know that there are going to be things that need to be course corrected, maybe tailored, sharpened. We want to get it right for kids. So do let us know your better ideas. And that concludes my part of the webinar. Thank you, Sam.
Thank you so much, Cindy. So we are going to be taking some questions now, but one question that we have already heard is about the role of the National Children's Chiefs Commission in the implementation of long-term reform. So we heard during the regional engagements very strong support for the commission to play an ongoing role in governance, but we don't see that reflected in the Loving Justice Plan. So Chief Frost, can you maybe speak a little bit to why that is?
Thank you. So if you look back at the Chiefs Assembly resolution and their direction, giving clear direction and mandate to the National Children's Chiefs Commission to review and analyze and come back with a national plan, moving away from the original agreement. And so the mandate was pretty clear, and the mandate ends essentially when we have a negotiated agreement for a tribunal-approved plan, and that is currently before the tribunal. All of the details were just highlighted for you by myself and Dr. Blackstock here, but after that, it's up to the chiefs in assembly to decide where they want to go with this and how the ongoing role what will that look like. Cindy spoke about the oversight committee. Well, we have some options, right, in moving forward, and we certainly want to be involved. We certainly want to continue on supporting that. But after that, in preparing ourselves for this new body and trying to fulfill the ongoing obligation, providing the oversight, it's up to the Commission and the Caring Society to present to the Chiefs and Assembly a new model going forward, and the Chiefs will make a determination. Now, just that highlighted what we have with respect to the National Children's Chiefs Commission. All of us are chiefs, so most of us are, and we have a technical committee, legal team supporting us, reviewing and analyzing the legalities of the agreements. We have a negotiating team ready to go in the event that we're triggered to look and assist and provide guidance in the future. We are ready at every angle to continue on this work. But in the meanwhile, it's our job is done when we've met the obligations of the chiefs and assembly. We will bring back the report to the assembly, and I'm anticipating that will be in the summer session. I believe that is in July. I hope that answers the question.
Yes, it did. Thank you, Chief. I have a question for both of you. The question is, are the Caring Society and the NCCC okay with the AFN's proposed date to the CHRT for closing the oral submissions for November 2026? Cindy, if you want to go first, and then Chief, you can answer as well.
Yeah, certainly we think an oral hearing in fall is reasonable. That provides sufficient time for First Nations leadership to review Loving Justice, review the Canada's plan, and to benefit from the various legal submissions that will come in the next few months. While respecting the fact that there are decisions that need to be made at the upcoming assembly in July. So anything before July feels premature. Leadership have already said in resolution, and Sam, you probably have it at your fingertips, but the 90 days that they want to see have to be able to consider material of this importance, and we certainly want to do our best to respect that.
Thank you. It's Chief Frost here, and I would concur with Dr. Blackstock. So just with respect to the National Children's Chiefs Commission, of course, time is of the essence because Canada's imposed their timelines on us. So, we also have to, give necessary reports back to the Chiefs and Assembly before finalizing anything. And, other than that, we will continue to work lockstep with the Caring Society and, of course, our partners at AFN to ensure that we work in time and with supporting all our respective regions.
Thank you very much. Question for you, Cindy. Can you provide a brief update on Canada's judicial review of CHRT 80?
Yeah, and thank you for mentioning that, Miles. Canada has applied for judicial review, and that's like an appeal, but that's the official language for it in federal court, of 2025 CHRT 80. That's the order that set down those minimum standards. Now, I just want to note for everyone that in those minimum standards are often in previous orders. So the tribunal was just summarizing its views there. So we don't know why Canada would try to get a judicial review of that section because the time for them to challenge that has come and passed. Just because a tribunal summarizes it, minimum standards doesn't open it up to re-review. So that's one thing. The second is that Canada's filing for of the motion for judicial review is very vague. You can find it on fnwitness.ca. We have done a close reading of it. We still are not clear what they actually don't agree with. Where it's at is a case management associate judge has been assigned. That's Associate Judge Mulgat. The Caring Society has indicated that it wants to bring a motion to strike that judicial review on the basis of prematurity, i.e., the tribunal has not made decisions on these plans. All it did, CHRT 80 did, was say, here are the minimum standards and here's the process for you to come up with a plan. And it would be open to Canada to pursue judicial review if it disagreed with the eventual decision that the tribunal makes. But it's too premature right now. And what we haven't heard back from the federal court at this date is whether they will hear the motion to strike before the actual hearing on Canada's motion or at the same time. So we're still waiting to hear that.
Thank you very much, Cindy. I don't think that we have gotten any more questions, and we're nearing the end of our hour for the Q&A anyways. So before we go, I just wanted to thank Chief Frost and, of course, Dr. Blackstock for all of their hard work, all of their support, and for coming today and doing this presentation for everybody. I'll remind the participants to keep an eye out for those upcoming additional webinars. Communication going out will be distributed shortly. And if I can ask Judy to close us in a good way. Thank you very much.
Thank you, Sam, and thank you, Dr. Cindy Blackstock and Chief Pauline Frost for the updates and the presentation. And we'll close in a good way today. Cooksjam, Cookbee Creator, we thank you for the discussions and the presentations of the information. We pray that'll settle with us and we can think about it over the weekend. And if we have any further thoughts, Creator, we pray that they'll be guided in a good way for the children and their families, because we truly are a collective work and collective will, Creator, to end the discrimination and racism our children are facing, especially with the imposition of further dividing and conquer to our children, because they're so vulnerable, and it must end that our children are used in this way, Creator. We pray that we have healthy families and healthy children and beautiful ways to raise them in the ways of our teachings and our wisdom from our ancestors and our elders, Creator. We pray for their safety, and that we pray for their love and their belonging, their sense of belonging in their families and communities, as all children ought to have, Creator. So we thank you for this time together, Creator. We pray that we'll continue to clear our path and open up the doors for us so that we're able to walk in a good way in all of these discussions, especially with the Canadian Human Rights Tribunal in their hearings and their review of the Loving Justice Plan and of the federal plan. We pray that the best will come forward and we'll be able to find the best solutions for the children today. So we thank you for everything you provide us, Creator, Mother Earth, the water, and all creation, our Consultant. And please help uplift our children, uplift our elders, and our knowledge keepers that keep guiding us in a good way. Cooksjam, 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 Cooksjam. Thank you, Sam.
Thank you.